Can a child talk to a judge in a child custody case? This is one of the most common and emotional questions that I get from parents involved in custody battles. In today's video, I'm going to break down when and how a child might be allowed to speak to a judge, what factors the court considers, and what you should do and not do as a parent if the issue comes up. Can a child speak to the judge? Yes, but it depends. The short answer is yes, but only under certain circumstances. In many states, judges have the discretion to decide whether hearing directly from a child is appropriate. This is more common in contested custody cases, especially when the judge is trying to understand the child's preferences or how each parent's home environment is affecting the child. But don't expect formal courtroom testimony like you might see on TV. Most of the time, if a judge talks to the child, it's in private, it's in what is called an in-camera interview, and it's without either parent present. Often, the child speaks to the judge in chambers, sometimes with a guardian ad litem or the attorneys present. At what age can the child talk to the judge? Another question that I often hear is something along the lines of, how old does the child have to be to talk to the judge? Well, there's no universal age across all states. But generally speaking, in some states, a child as young as 12 may be considered mature enough to express a preference to the judge. Other states might allow a child to talk to the judge if the child is 14 or older. And in some states, the judge always retains discretion regardless of the age of the child. But remember, even when the child is allowed to express a preference, the judge does not always have to follow it. The judge's top priority is always going to be what's in the best interest of the child. How much weight does the child's opinion carry? The court takes many factors into account, not just what the child wants. The child may say he or she wants to live with dad because dad just might have looser rules. The child might say the child wants to live with the mom because, well, maybe the mom just bought the child a new phone and the child feels pretty good about mom in that moment. The judge is going to look at the big picture: emotional stability, school performance, parental behavior, and more. In fact, the judge has a set of factors that the judge is supposed to look at in determining what's in the best interest of the child. In some cases, the judge may feel that even though the child is old enough to express an opinion, that opinion was influenced or perhaps manipulated in some way. That's why judges are very careful when it comes to this particular aspect of the child custody case. What parents should not do. If your child may be asked to speak to the judge, here's what you should not do. Don't coach the child on what to say. Don't pressure the child to choose sides. Don't make the child feel like he or she has to defend you. This kind of pressure can backfire, and judges are very good at picking up on it. Instead, focus on being a stable, supportive parent who keeps the child out of adult conflicts. What if you want your child to be heard? If you believe your child has something important to say, you may not need to rely on them speaking directly to the judge. Some other options include having a guardian ad litem or a custody evaluator speak on the child's behalf, or submitting reports from school counselors, therapists, or teachers. But be careful with this because there are rules of evidence that have to be followed, and people who represent themselves get in trouble all the time because they incorrectly think that they're going to submit some information, and then they get caught off guard by some objection that the opposing party gives that destroys their plan. Talk to your lawyer about the best strategy for your particular situation. The key is making sure that the court hears what's important without putting your child in the middle. If you're facing a custody battle and wondering how the child's voice fits into this case, I invite you to schedule a confidential conversation. Let's build a custody strategy that puts your child's well-being first and protects your parental rights. Subscribe for more custody and family law insights.